Okay, for those students who are not able to attend the class, last meeting, I will discuss today recruitment and placement of workers. My presentation would be, I group that into two. We will discuss domestic recruitment and then overseas recruitment under Migrant Workers Act as amended. There are still applicable laws governing domestic recruitment. There are entities that are involved in domestic recruitment for the local employers. For example, they provide domestic workers, drivers, house helpers. So the article that governs this one, we start with Article 25 of the Labor Code. Under Article 25, it recognizes the role of the private sector in the recruitment and placement of workers locally and overseas, subject of course to the guidelines and rules and regulations imposed by Secretary of Labor. So the entity involved here are called the Private Employment Agency. It refers to any person, partnership, or corporation engaged in the recruitment and placement of workers for local employment. It shall also refer to any individual, partnership, or corporation or entity licensed by the Department of Labor and Employment to engage in the recruitment and placement of kasambahay for local employment. This is provided in Section 3, Paragraph G of DO 141-14. Now, another thing that you will take note when it comes to a private employment agency would be that it must be owned at least 75% by Filipinos. And this 75% should be the authorized and voting capital stock under Article 27. It's very important that this is dominated by Filipinos so that the interest of Filipino workers will be protected. If you will be asked of the requirement for the registration as private employment agency, it requires a minimum of 1 million net worth in case of single proprietorship and a paid-up capital of 1 million in case of partnership or corporation. And another important requirement is that it must not be disqualified under the governing rules and regulations. Section 5 of the said department order provides the disqualification. So I'll just give you the enumeration. 1. Those who are convicted of illegal recruitment, trafficking, anti-child labor violation, or crimes involving moral turpitude. So as law students, you know already the meaning of convicted, which means that there's already final judgment. For cases involving illegal recruitment under Migrant Workers Act and under this law, you have trafficking in person, 9208 as amended, and anti-child labor violations, and more importantly, crimes involving moral turpitude. Another disqualification would be against whom probable cause of prima facie finding of guilt for illegal recruitment and other related cases exist, particularly to owners or directors of agencies who have committed illegal recruitment and other related cases. Now, these probable causes here, probable cause is determined by the public prosecutor and also determined by the judge when it issues the warrant. So, once you have the criminal complaint filed by the public prosecutor and there is the judge issuing also a warrant of arrest based on probable cause, then you are disqualified already from registering. Another disqualified entities would be those agencies whose licenses have been revoked under Section 54 of these rules. So there are grounds that the licenses will be revoked, and once you have already a license that has been revoked previously, you cannot apply. Cooperatives, whether registered or not under the Cooperative Act of the Philippines. The essence of cooperativism is to help, not exploit human beings. Indirectly, when you engage in recruitment and placement of workers, you are making profit out of human labor, or technically like selling human labor. So this is inconsistent with the principles of cooperativism. Another disqualified persons or entities are law enforcers or any official and employee of the DOLE for very glaring reason. These persons may use their authority. Then sole proprietors of duly licensed agencies are prohibited from securing another license to engage in recruitment and placement. So if you're a sole proprietor involved in private employment agency, you cannot secure another license to engage in the same kind of business. The last one would be sole proprietor, partnership, or corporation licensed to engage in private and placement for local employment are prohibited from engaging in labor contracting or subcontracting activities. To avoid using the recruited employees under PAA and place them in your job contracting companies, that is prohibited, because the employer here, the recruitment agency, is prone to abuse. Instead of sending them to a kasambahay or an employer in need of kasambahay, they will just recruit them and make them work in their agency to perform messengerial or janitorial job. So those are the different disqualifications. So just familiarize and take note, because you might be asked in the exam or in the bar exam. At least you have an idea that there are rules, there are laws and regulations governing the hiring of domestic workers. The question now is, can an agency who is engaged in recruitment of workers for overseas employment can also do business in providing local employment, or performing as private employment agency? This is allowed under section 6 of DO 141-14. And one last thing, this PAA, although there is already a license, once it is registered, the POA is also authorized to recruit if there is only an authority given by the regional director. Without the authority to recruit, the activity would be illegal. So it is required. Okay, for further enrichment, just read the succeeding provisions of DO 141-14. Now let's go to Migrant Workers Act as amended. We are talking here of RA 8042 as amended by RA 9422 and RA 10022. There was a case that reached to the Supreme Court questioning the constitutionality of this law. The case of Executive Secretary versus Court of Appeals, May 25, 2004. In this case, the Supreme Court upheld the constitutionality of this law as vis-a-vis the arguments of the petitioners alleging that it violated the Equal Protection Clause and the Non-Impairment Clause of the Constitution. According to Supreme Court, there is a valid classification of overseas Filipino workers because this particular group needs the protection of the government, they being subject to abuses by foreign employers. So there is no violation. We learn in your political law that if there is a valid classification, there is no violation of Equal Protection Clause. The next argument would be the Non-Impairment Clause. They have already signed contracts. Prior to the enactment of this law, there were already contracts signed between the agency and the principal. And because of some prohibitions under this law, these contracts could not be enforced. And with that, they brought this case to the Supreme Court, alleging that the non-impairment clause in the Constitution was also violated by this law, making the law unconstitutional. The Supreme Court ruled otherwise. There is no violation of the non-impairment clause because the Migrant Workers Act is a valid exercise of police power. The rule is settled. Police power prevails over the provision of non-impairment clause in the Constitution. So ergo, this Migrant Workers Act has been declared constitutional by the Supreme Court. Now let's go to acts, which are considered illegal recruitment. So here we will classify the acts that are punished. First, let's go to Section 6 of RA 042 as amended. What are the acts punished? So we are talking here of the first act. When it comes to canvassing, enlisting, recruitment, transporting, utilizing, hiring, etc., undertaken by non-licensee. So this is considered illegal recruitment. On the second paragraph, there is another act also that is considered illegal recruitment but can be committed both by licensee and non-licensee, or non-holder or holder of authority. So what are these acts? It's enumerated in second paragraph of Section 6. For instance, to charge or accept or directly any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary of Labor and Employment, or to make a worker pay an amount greater than that actually received by him as a loan or advance. And there are many enumerated here up to paragraph N. In the enumeration in second paragraph, there is the amendment added by RA 10022 when it added paragraph N, declaring that if there is a non-Filipino citizen who is heading or managing a licensed recruitment agency, is considered illegal recruitment. So that is the amendment of the law. So if you will be asked, what are the acts punished under Migrant Workers Act? So the way you answer it would be, first act punished is the act of illegal recruitment, found in first paragraph of Section 6, RA 042, and second paragraph. These are considered forms of illegal recruitment. The first paragraph is committed only by non-licensee or non-holder of authority. The second paragraph can be committed both by non-licensee or licensee, or a holder or non-holder of authority. So that is the first group of acts that is punished, or acts that are punished under Migrant Workers Act. The second group that is also considered punished are those introduced under Republic Act 10022, and these are described as prohibited acts. And these prohibited acts can also be committed by licensee or non-licensee. What are these acts? There are enumerations. For example, grant a loan to an overseas Filipino worker with interest exceeding 8% per annum, etc. Another one imposes compulsory and exclusive arrangement whereby an overseas Filipino worker is required to avail of a loan only for a specifically designated institution or entities. So, just go over with these acts enumerated so you will know what are the acts that are considered punished under Migrant Workers Act, or in other words, these are criminal offenses. So you have to group them into two. The first group would be acts that are considered illegal recruitment under first paragraph Section 6 and second paragraph of Section 6, and you also have the second group that are considered prohibited under 10022. You have to distinguish, because when it comes to penalty, the punishment for the first group is higher than the acts considered prohibited. Okay, so since illegal recruitment has become a favorite question in bar examination, usually the bar examiner asks this, no? What are the types of illegal recruitment? However, this is a very tricky question because candidates answered this way, no? Large scale and syndicate. That answer is wrong because when you talk of illegal recruitment, there are only two types: the simple illegal recruitment and the economic sabotage or the qualified form. So when you talk of illegal recruitment, the simple illegal recruitment, the elements here would be: first, there is an act of recruitment or placement, or there are recruitment and placement activities, and these activities or acts performed are done by non-licensee or non-holder of authority. So this is considered simple illegal recruitment. On the other hand, you also have your economic sabotage or the qualified illegal recruitment. So under disqualified illegal recruitment, you have the two types, but committed by syndicate or large scale. The point here is from the framework of the offender or the offended party. So if we are talking here of the offender, we are talking of syndicate. The number here is 3 or more. So if it is committed by 3 or more persons against any person or persons, then it is considered syndicate. It is considered large scale if it is committed against 3 or more, although it is committed by individual person only or more than 2 persons. So it's the same thing. So if it is economic sabotage, we are talking here of qualified illegal recruitment, which means that the maximum penalty will be imposed. So when you talk of illegal recruitment in large scale, first, in the case of People versus Sigon, the offender here has no valid license or authority. Second, the offender here undertakes either of the activity as enumerated, no? The meaning of within the meaning of recruitment and placement, prohibited under Article 34 of the Labor Code. And then the offender commits acts against 3 or more persons individually as a group. So this is the requirement of large scale. So just take note of that case. On the other hand, you have to remember also that illegal recruitment, to make it qualified, is not only limited to the number of offender or the number of offended party. It could only be that it could also apply if the offended party is only 1 person, but that person is a minor, so it is considered qualified. The penalty also is maximum. Usually, those are the questions in bar examination regarding illegal recruitment. However, we have to discuss also other topics related to illegal recruitment for appreciation and just in case other questions will be asked, no, other than the types of illegal recruitment. You also have to discuss the person's criminally liable. This is especially penal law is adopting the revised penal code, no, criteria of persons criminally liable. We have the principal, accomplices, and accessories. In order to emphasize the gravity of the offense, the state penalizes principals, accessories, and accomplices. So, for definition, you know already the meaning of principal, accomplices, and accessories under your criminal law. So, another probable question also in bar examination would be the liability, no, of the local recruitment agency and the foreign principal. Under Section 10 of RA 042, the liability of the principal and the employer and the principal or employer and the recruitment or placement agency for any or all claims shall be joint and several. Under your civil law, if the principal or if the employer here, the agency is liable for any claim, then we can ask for reimbursement from the principal abroad. So when it comes to filing of civil cases or damages here, you cannot sue the principal principal abroad, especially if they don't have office here. So if they have office here in the Philippines, the principal abroad, then you can sue either of them because the liability is joint and several. In most cases, since there is what is existing here is only the recruitment or placement agency, then you only sue the agency, and the agency cannot raise the defense that it is not liable, because the liability is joint and several. So again, when it comes to prosecution of cases, the filing of cases, here are the things that you will remember. If the entity committing the crime of illegal recruitment has no license, then we cannot use the administrative because there's no license to revoke. We will just file Estafa and illegal recruitment, and in case you want to separate civil aspect, you can separate. If the offender is a licensee or a holder of authority, you can file for revocation of license. And then you can also file a labor complaint, because the jurisdiction of payment or non-payment of money claims of YFW is with the labor court. And then you also file criminal cases for Estafa and illegal recruitment, as the case may be, if it falls under second paragraph of section 6 of RA 042. Then you also have the civil cases. So to summarize, if you will be asked what will be the cases that can be filed against offenders committing illegal recruitment, first you have to distinguish if the offender is a licensee or a holder of authority. Then you will enumerate the following: administrative cases for revocation of license, second, a labor complaint before the NLRC, third, Estafa, then fourth, illegal recruitment. So in the latter cases, civil cases can be instituted when the case was filed in court. So on the other hand, if the entity committing illegal recruitment has no license, then we will file illegal recruitment, and we will file Estafa and damages, if not deemed instituted. So there is a criminal liability for illegal recruitment. So to distinguish, the penalty for illegal recruitment, simple, is not less than 12 years and 1 day, but not more than 20 years, with a fine of not less than 1 million and not more than 2 million pesos. When it is economic sabotage, the penalty of life imprisonment and the fine of not less than 2 million and not more than 5 million. Then, to distinguish, because RA 1022 enumerated prohibited acts, paragraph C of section 7 of RA 042 provides that persons guilty of prohibited acts shall suffer the penalty of imprisonment of not less than 6 years and 1 day, but not more than 12 years. Okay, so there's a difference if you prosecute simple illegal recruitment and economic sabotage in terms of penalty. Regarding of prescriptive period, if it is simple illegal recruitment, then you have 5 years. If you have economic sabotage, then the prescriptive period will be 20 years. So if you will be asked to distinguish again types of illegal recruitment, you have the simple and then the economic sabotage. In addition to what we discussed, you also include the difference in prescriptive period, because when it is simple illegal recruitment, the prescriptive period is only 5 years from the time the offense is committed. And when it comes to illegal recruitment involving economic sabotage, the prescriptive period is 20 years from the time it was committed. So that's very important to make your distinction complete. So it would appear that when you will be asked the question of distinguish the types of illegal recruitment, you have to give a comprehensive distinction. You have the simple illegal recruitment based on the elements committed, and you also distinguish that with regard to the penalty, and then you also distinguish that with regard to the prescriptive period. So it requires 3 answers. Okay. Another principle it may be asked in the bar examination would be the principle of reciprocity under section 4, as amended by RA 1002 of 22. So which means that the government shall not deploy OFW workers to any country that doesn't have the following. So the following country must have either of the following: it has existing labor laws and social laws protecting the rights of workers, including migrant workers, or it is a signatory to or a ratifier of a multilateral conventions, declarations, or resolution relating to protection of workers, including migrant workers, and it has concluded a bilateral agreement or arrangement with the government and the protection of rights of overseas workers. And provided further that the receiving state is taking positive concrete measures to protect the rights of migrant workers in furtherance of any of the guarantees under the paragraphs mentioned. So that is the principle of reciprocity. And another thing regarding the jurisdiction of money claims, death benefits, and other benefits of OFW, under section 10 of RA 042, it's now with the National Labor Relations Commission, or with the Labor Arbiter. So what is left now with the POA would be the administrative power of the POA. So they can hear disciplinary actions and special cases administrative in character involving overseas Filipino workers. This is provided in the case of Eastern Mediterranean Maritime Limited and Ajimar Manning Agency Incorporated versus Stanislao Suryo et al. August 23, 2012. So if you'll be asked of the jurisdiction when it comes to disciplinary actions over overseas Filipino workers, you file it with the POA. When it comes to money claims, you file it with the Labor Arbiter. And there is also the principle of country team approach, where it is mandated under section 27 of RA 042 that all officers in the Philippines in the foreign country will form as a team under the leadership of the ambassador to promote the welfare of Filipino migrant workers. Under section 28, there is the mandate, that all officers shall act as a team and address the exigencies or the problems of Filipino overseas workers situated in that country. So they are there to protect the rights. This is our learning experience from the floor contemplation case, where the officers of the Philippines were pointing fingers at each other. So this will not happen now because there is the mandate of country team approach. And finally, do not forget that under Republic Act 11227 or the Handbook for OFW Act of 2018, there is the mandate here to provide handbook to overseas Filipino workers before they go abroad. So the POA is mandated to provide a handbook informing the basic rights of Filipinos who are going to work abroad. So that's basically the amendment, the last amendment, the newest amendment of the Migrant Workers Act.